Good morning, everyone, and welcome to our session, which is about resolving disputes before the court. So various forms of ADR. I was pleased today actually to hear Lord Bellamy say we'll drop the alternative, and for me I think that's a very key point. It should just be dispute resolution. There were three questions that we were asked to consider today. What we thought we'd do is just 30 seconds each on the panel. We'll give our views on the questions. What we're really interested in is the views on the board and also the views from everyone online. So welcome to those who are in the metropolitan building, so to speak. It's nice to see you today. So I think the first question was, how can dispute resolution be encouraged through greater use of alternative dispute mechanisms? So
yeah, hi. My name's Andrew Higgins. I'm the Professor of Civil Justice Systems at the University of Oxford, academic member of the CJC. I'll probably start by focusing on what I'm doing at the moment. I'm chairing the CJC review on production protocols. We're probably weeks away from issuing our first final report on that. Certainly be out by Christmas. What I'm very likely to recommend is that there's essentially a general obligation to engage in the actual dispute resolution before going to court. There'll be obviously lots of details to be worked out as to which areas of litigation that would be appropriate. During the consultation, some indicated that it may be, but if I were a response, it probably is that but we do think if we can get the funnel and people are using these, then it does open up the opportunity of providing information about ADR options available to parties so that they can work out what's the best ADR process for them before that issue proceeding.
So I'm John Sirachi, I'm also from the CJC, and also teaching ADR as well. I suppose if I were to think about how you can encourage the use of it, there are things that you could do, potentially. Mandatory is one option. That would certainly encourage its use if you have no choice. But perhaps if you took a more optional approach, you could encourage through the use of financial incentives, so funding would be provided for the take-up and use of ADR, and particularly we're thinking about, the point made earlier, that government has now realised the benefits of early resolution, dispute resolution through the courts, because of the financial benefits in other areas. So we promote ADR through the use of accessibility funding for it, and that would be the most encouraging. Then you can start to really possibly do a resolution in your team actually deciding.
So my name is Richard, and I'm the top of the insurance representative of the Justice Council. I think the funding is a really interesting point. Who is going to fund it, and how it will be funded, and whether the companies or
my answer to that might be one potential answer to that, and it's being looked at in Canada, is mandatory legal expenses insurance. You do it through that approach. And in terms of premiums, because some people will get premiums, then perhaps the state needs to stand up and actually roll that into welfare benefits for those who find it so good.
It's a really interesting point, and actually legal expenses to utilise although people have it as level.
Yeah, and actually make people aware that they do have it on their car insurance, their home insurance. Some bank accounts have it, mobile phone, mobile banking. So there are lots of ways in which it's already there that you might actually be able to relate to them.
Yeah,
still in our minutes also because of less amendments or two to the sections that we've seen. Again, I wholeheartedly agree. Yes, we need resources, we need to do what Johnson maternity, which is this interesting insurance approach to funding curriculum. But one of the other things I found fantastic is I'm engaging with the ADM process of the action series. And this would actually highlight more to it, the potential to use that process to navigate issues if the need to have been resolved. So it's not a one-stop shop, essentially. If you want something, that's it. There's nothing to take from the process. So this idea of using the CAP process, if it's ethical, that's great. If not, it still can be used to narrow some of the issues that have to be parts closer together. One, certainly can possibly take place later on, and secondly, can how more efficient judicial-based management so trying to approach parties who look at different ways of this kind of thing. It's not all about something because that's great, but
So I don't think in doing those online blogs, any questions or observations?
Thank you. Tony Guys, Disputes e-filing. There are a number of consultations that have either closed or are about to close, as Andrew Higgins mentioned. And there's also work going on with the Ministry of Justice. Yesterday there was an engagement exercise with online dispute resolution providers. My question is to the panel is to the extent to which, when one considers compulsory or mandatory mediation, how far has the question of digital delivery of ADR been considered as a way of engaging with users to just take the step rather than, as it were, using a stick, using the carrot of the next step once you've completed your details, name, address, nature of claim, etc. The next step is ADR. To what extent has that been reflected in the work of the pre-action protocol review? Thank you.
Yeah, I mean, so essentially the idea is 3 steps in the progress. The first is just identification of the nature of the problem and the nature of the disputes, key relevant information exchange between the parties. And then we want the second step to be, okay, now we talk about what are the solutions, what are the options to resolve it. And we wanted to make that more prescriptive. So I choose the best kind of dispute resolution because it works for them. And then the third step would be essentially what Masood was talking about. If it doesn't resolve it, what have we agreed? Have we been able to agree anything in a way that can actually narrow the issues should we get into issue? So that's essentially the structure. In terms of digitalisation, yes, we're trying to work out ways to do this online. We had some extremely lengthy and quite technical discussions about whether it's possible to have without previous communications through online portals and whether that works and whether that avoids confusion. We have rules basically saying it could be a disaster. Some of the technology experts will move confidently it can be done. So that kind of detail needs to be worked through. But obviously, if you can have these dispute resolution processes conducted online, then obviously the efficiency benefits.
I think it's one of the factors recognise there's a whole raft of ways to bring a case to settlements pre-issue by a whole raft of means of dispute resolution. It's not just mediation. I'm actually quite passionate about this, that you've got to give them various options. It's got to be the right option for the nature of the dispute. So there is acknowledgement in the work that the various ways in which parties can use it for dispute resolution is not just.
Yeah, so we're trying to signpost as well. So ombudsman, ADR schemes, mediation, getting mutual evaluation. So it's not just an obligation, but also a very active participation. Spread the word about systems and value.
I think as well it leads quite nicely into another sort of topic to this question, which is education. think there has to be a really big educational piece. You know, in some areas, so if you look at, say, family, for example, and the mediation assessments, information piecing, you know, that is really clear. You certainly do research that brings, you know, very simple, easy to understand language with videos and videos as to what that process is about. I'm not entirely sure that we've got something like that yet, generally, for the dispute resolution. And I don't know if anyone in the room or online has got any observations about that.
Thanks, Stephanie Needleman from Justice. Mediation in family, though, isn't actually working very well. We've seen a huge drop-off on mediation since LASPO came into force, which I think illustrates a wider point when thinking about alternative dispute resolution, or dispute resolution as it's now known, is what do you do when you have parties who either, like in family often, aren't emotionally ready to engage with each other, or like we heard this morning, aren't able to identify their rights, or there's a gross imbalance of power, like the landlord-tenant relationship.
I think they are really, really good points, and that's one of the, you know, when we go back to data, why aren't, you know, parties ready, and what do they do when they can't engage in the system? Where do those individuals go? What remedy are available to them?
Yeah, so that's a good question. So clearly there are a lot of people in a lot of sectors who think that there shouldn't be a mandatory dispute resolution obligation pre-action in cases where there is severe power imbalance. And that's certainly, I mean, we even flagged that in our initial report that there may be some areas where that's not desirable. That said, there are also some areas where trying to get you know, defendant agencies, defendant corporations, case may be, to engage with people's problems, I think is also something that we should explore. And I know, a question I have is a lot of some ADR providers think they can do it, even in cases of power imbalance. I know there's a mix of views on that, but I'd be interested to hear what people in the room have to say.
Hello. Can you hear me? Is that working? My name's Ellen Taylor. I'm from Derbyshire Law Centre. I work in employment law, so we already have a requirement to go to ACAS for early conciliation, which can work very well. So it can do all the things. It can resolve disputes. It can clarify the issues. But we have 6 weeks in which to do it, which is quite a long time. And it's very variable because it depends on the capacity of the conciliators, who are sometimes very busy, and sometimes it doesn't work at all. So it depends. I think it depends on funding. It depends on having a system where people are encouraged. I mean, ACAS very much encourage people to engage with the process, but you can opt out, and I think that's right. But it is a very unequal relationship as well with employers and employees, or ex-employees. And I think it works better when we're doing it on behalf of clients, because we understand the issues, and there's a greater equality of means of, you know, more equal standing. But I think it's harder for our clients when they're not represented, because although ACAS are independent, and you know, they don't. It just, employers have more resources. They may be legally advised. Our clients may not be, or people we aren't representing may not be. And so I think it's quite a complex. It is quite a complex situation. I think it's very hard to set up a system which makes it work for everybody.
I'm a District Judge, Graham Stewart, at Manchester Civil Justice Centre, doing civil and family. I accept that the ones that end up in my court are usually the ones who are already started throwing the grenade at each other. But let me just deal with the civil part first. I think you've got to distinguish between the big insurance companies, the people with money, who will commercially go to mediation, possibly or arbitration or whatever. And the man in the street whose builder's not done the work, who's only on £200 or £300 a week, and I'm afraid I did object a little bit to what was said on the front bench today. Why do people for £10,000 go to court? It's not commercially worth a while, because £10,000, £5,000, and if you're on 70 quid a week, 100 quid is a lot of money. Let's just live in the real world, everybody. And a lot of these, you're not going to go to mediation or arbitration against your builder. You've been trying to sort it out with your builder. You've been phoning him 5 times a day. He's not answering the phone. You need, I'm afraid, to issue proceedings. And controversially, I've seen some courts do this. I would do this. You issue the claim, you issue the defence, you're in front of me in about 2 weeks' time if we've got the judges for early, inverted commas, evaluation, arbitration. Actually, I can make a decision and hope that the senior court support me. Sorry, you've got a nonsense defence here, Bill. You haven't done this. I've seen the picture, or whatever it might be. You're out. And there might be a mechanism for going on after that. I do not know. But that might actually be, because sometimes you've got to see the court, the judge's eyes, to actually suddenly say, actually, this is now serious. Which brings me over to family cases, where the amount of urgence I get, Manchester, I think we've had 6 today. I was just looking at my phone. We get them all the time, injunctions non-stop. They dodge the MIAM. They don't go to mediation. With mediation, or someone will promise to go to mediation or whatever, you're not seeing your kids. You're now not seeing your kids for another 8 weeks, waiting for mediation. It's not worked. Now you have to issue. Now you have to wait another 6 or 8 weeks for FEDRAs. That's if CAFCAS are even up to 6 weeks. I'm afraid they're not a lot of the times. And you're now months away from seeing your child. So it's all very well in principle going for mediation. It's great theoretically, but in the real world in which I live in, the people which I deal with day in, day out, it doesn't work for them. It might work for some, but generally you don't see those. The parents that might sort it out with the grandparents, or the legal aid I was a legal aid lawyer for 35 years representing the disadvantaged in Blackpool. We didn't go to court often because the lawyers would phone up, John, I'm doing Mrs. Smith's case, you got Mr. Smith, shall we sort it out? Yes, we can. But and I heard all that nonsense this morning about how much money being put in legal aid, changed and stuff. It just doesn't work in the real world, which I live in. Until we can get back to that, which is not going to happen, I'm afraid arbitration, mediation, I know you're all keen, I'm a bit of a dinosaur here, but in the world I which live in, it doesn't necessarily work. You've got to distinguish which cases you can send to it and which cases, I'm afraid, a judge at some early stage has to deal with.
I think that's very helpful.
Yeah, very, very good points there. Now, I think that the way to look at it is what we should be doing, and we're trying to do, is to say, open up the options and dispute resolution. And that doesn't necessarily mean you have to go to mediation and that's the only option. And I would be very supportive of that. Judges stepping in and doing judicial evaluations when the issues are crystallized into a marriage stage. And I think that's an emerging sort of way of resolving disputes. And we've had a number of interesting cases. We've had a number of interesting cases lately, Lomax and Lomax being one of them, in which judicial early neutral evaluation was promoted. And so I think that the powers are there within the civil procedure rules under CPR3 and the overriding objective to do these things. And I would definitely agree with what you're saying in terms of the judges are also playing an active role in trying to get the parties to settle. And I think the way we see the PAPs and the reforms with the PAPs, I think that provides that way forward. It's not again, as I said at the beginning, not a one-stop shop, that's it. But and I think that needs to continue, that ongoing dispute resolution.
Yeah, I mean, we are conscious of this delay problem or this sort of non-engagement problem. So we have spent a lot of time, particularly me and Masood, trying to work out ways we could structure PAPs that in effect are operational when people are engaging, but not barriers when people aren't. So so the obligations would all be sequential, so that if the builder doesn't respond, then that's an immediate pass for the claimant to go straight to court. So we want sort of off-ramp options. But the idea is so that where the parties do engage, then we have dispute resolution options of the kind that Masood is talking about, and non-prescriptive. So we'll have, there are obviously some processes are more expensive than others. It can be as something as easy as straightforward as a pre-action meeting between the parties, and in some cases that will have already happened. But these are processes for people who are engaging as opposed to people who aren't. If they aren't, we then want the ability to go straight to court.
I would just agree with that. We're talking about resolving disputes before court, but that assumes that it can be. And the point that the District Judge Graham Smith mentioned, I entirely agree with. The focus a lot of the time is on the alternatives. I'm going to still call them alternatives, although I'm a dispute resolution person myself. But they are alternatives, and in focusing on those, we don't want to, and we really shouldn't forget about litigation, because it's access to litigation that really gives, first of all, the power, insofar as it has any, to these alternatives. Without the possibility of getting easy access to the court, to the judge, then we could string out a negotiation, a mediation for as long as possible. So we have to have the off-ramp. That's crucially important, and it also has to be something which the parties to a dispute know about. Now, how are they going to know about it effectively? Because it's all well and good devising a pre-action protocol that reads very well and parties could use if they understood it. But how are they going to get that proper understanding? Well, you could devise a digital system, but we heard this morning about the problems of accessing digital systems. So how do we do it? Well, I talked about the panacea for funding at the start, which I think is legal expense insurance. So the other panacea that I would have, and actually it's quite shocking that I talk about it in terms of a panacea, is access to a lawyer, and ready access to a lawyer. Because the PAPs and most of the things that we're doing now are all designed around the idea that Michael Briggs promulgated in 2015, that we're designing the system to be lawyerless. Well, we shouldn't be designing lawyerless systems at all. We should be designing easily accessible systems that have lawyers embedded in them. We shouldn't be in the approach of seeing lawyers as redundant. They play a crucial role. You, lawyers in the room, play a crucial role. And if we put the funding right, and if we get the PAPs right, and we get the lawyers in the room advising the parties, that deals with the power imbalances, as has been said. But it also ensures that the options, whichever the option for settlement may be, or resolution through litigation and a judge, are the ones which parties choose which suits their case. And that's really the way in which we're going to resolve disputes effectively, whether it's before court or after court, is enabling parties to choose the right resolution mechanism. And you're only going to do that if they're properly advised.
Hello, I've got the microphone here, so if I could jump in. Can we come back to the first question? Because I think everyone's tending to look at this from the wrong end of the telescope. And the wrong end of the telescope is when things have got to court or near to court. There are three things that everyone agrees on. Firstly, that business disputes, and I'm talking from the standpoint of business versus business mainly, business disputes are enormously costly to both businesses and the economy. Secondly, everyone agrees, and the research shows, that most smaller businesses regard lawyers as too expensive and court proceedings as too expensive for a lot of their disputes. And the third thing is how those businesses get to know about any other dispute resolution possibilities. It's a question both of education and of presentation. It's no good having something called a pre-action protocol if people think that it implies that you're going to have to take action, you're going to get involved in court proceedings. What you need is something earlier. You need a trusted source like ACAS that can give you dispute resolution options, website backed up with helpline, which is trusted by businesses, that businesses can go to before they even think of courts. That's the early time when these things are going to get resolved before people become entrenched. And it's no good the Ministry of Justice and the court service branding things court service, because that's going to turn people off. So you need something that doesn't look like the court service, that doesn't look like the Ministry of Justice, that tells people in a trusted way about dispute resolution, gives them the information, triages by helpline or website what they're doing, and tells them what those options are. One of them might be the pre-action protocol, but at least you get people engaged that way. The same question over and over again, how do we engage people? And the answer is not via the court service.
Not sure. Regional judge.
Really, so I'm really sorry. I didn't spot that in the chat. Sorry. All I wanted to say was basically we have both judicial mediation and mandatory alternative dispute resolution appointments in the employment tribunal, and I hope we live in the real world. The judicial mediation is voluntary and by consent only, and that works pretty well. We have something like a 70% success rate on people who agree to go mediation. And then we have in my region mandatory appointments for cases which are listed for more than 5 days. And we don't have such a good success rate for those. It's something about 40 to 50%, but I think that's good because it shows that not too much pressure is being put on people to settle. And of course, there are cases that need to be heard. But using the mandatory appointments at a later stage as a fallback when people have already exchanged witness statements, we've saved more than 900 days over the last 2 years. And it has really helped us keep the delays down for the cases that need to be heard. So I think there is something to be said for it. And also there's something to be said for thinking about dispute resolution, not through a hearing, at later stages as well as early stages, because in our case we're able to control the number of cases that settle at the last minute and free up time to get cases heard earlier. So it's really worth thinking about. Thanks. I hope that was clear.
Thank you. Hopefully everyone can hear me. Bad timing, but I'm Emma from the Courts and Tribunal Service. I lead on civil insight, so I'm afraid my question is going to come mainly from a civil. We've done a lot of research looking at mediation over the last one. Masood knows very well what we've been doing on. But I have a couple of questions more for discussion. I'm afraid I might disagree with you. I'm not sure lawyers and solicitors are the answer for people understanding their rights, because for a lot of people that is simply out of reach to them. A lot of the vulnerable users we do simply don't have the money or the access to a lawyer. But really my question is, how do we educate users to make the right choice for them? So it might be all well and good putting the options within the pre-action protocol, but how do we educate them about what those options are, what their legal rights are for their case, and how we get them to make that right decision, and then go to that dispute resolution with the right expectations and the right kind of approach. That was the end of my question.
I think there's a question at the back as well. Maybe we take the question at the back and then we can have a discussion about.
I think we have one at the front.
Hello, I'm Tim Wallace, Trust Mediation, Trust Arbitration. I just wanted to offer a little balance, because I was beginning to think that mediation and ADR wasn't such a good idea in the real world and didn't really work. And I can only speak to the parts of the forest in which I inhabit. And one is a mediator and a mediation provider with the NHS resolution mediation scheme dealing with clinical negligence. And we saw a pattern there when that scheme started 5-6 years ago. Mediations were very close to trial. We now see over 50% of our mediations pre-proceedings, with an 80% settlement rate, and that includes cases where the NHS wish to use mediation transparently and visibly to say to a claimant, we really don't think you've got a case, we'll talk to you about it and we'll listen to you, but we think it's time to discontinue this case. And sometimes that ends in a resolution of the claimant going away, and sometimes, in fact, the NHS change their mind. So there's some pre-proceedings. It's also online, courtesy of the pandemic, and has been very successful online, and people are now choosing to use mediation online in many cases, rather than get back to the quotes normal way of doing things. Personal injury. ADR doesn't work in personal injury. We all know that. There's a ring fence around it. You can't use ADR in personal injury. Trust arbitration works with a tech provider to provide arbitration in low value personal injury claims. Many major insurers are talking to the organisation. Some have signed up. Many major law firms who are dealing with the vast majority of OIC claims are also signing up, because ADR online does work. Not for everyone, not all of the time, but just to redress the balance in the room. I was beginning to get the idea it was all not working.
It just it brings, you know, what you've just said about the NHSR is very interesting, because there's been a real educational piece there as well, hasn't there, and a change in approach to do with those clinical negligence type claims. So do you think that holistic approach that was really driven, wasn't it, by the NHS and the changes in the process has actually helped claimants come to ADR in that type of claim?
It's also interesting, so that we like the state for insurers, how I use communication, but different insurers use it.
In terms of the just the personal injury aspect, it's more of an observation in that with the official injury claims portal, ADR was initially a fundamental part of that pre-issue process, and then when the build took place, I think one of the reasons was the number of claims that potentially would be in the system, and also that you know, you would just have ADR potentially for litigants in person, rather than everybody who's utilising the system. So ADR was removed from the process. Now, maybe for other reasons at the moment, we've only had 55,000, was it, this morning settlements, and I think we've got another 100 or so thousand that are in that system, probably waiting for the Court of Appeals direction later this month or early next. But I think the point there is that claims are still settling in the OIC between normally an insurer and a represented claimant, and actually the stats showed that the LIP claims in the OIC were actually settling quicker with the insurer direct when they weren't represented, basically. So I suppose the question back to you, Tim, is do you always need ADR, or can you have a digitised process that supports a pre-action protocol that
You can still have negotiation on a digital platform, and there are many benefits for doing that. And in fact, that's part of the service which is offered. So I think
one of the other questions that we need to get on to really is informing the public, isn't it? How do we inform the public about not only the pre-action protocols, but also about options? I mean, ACAS is one that's you know, it is fairly well known, but how does the employee get to find out about your services, and is there things that we can take from ACAS that we could utilise in other areas, for example?
I actually work for a law centre, but we use ACAS a lot. I think before you take an employment tribunal claim, you have to use the ACAS service. So if you click on the Start a Claim button on gov.uk, and I have to say that part of gov.uk seems to work fine, that then directs you to ACAS first, and there's advice, and there's obviously the form that you fill in for the early conciliation. So that's how that works, and then you can either opt for early conciliation, or you can just get the certificate you need. But it means that before you take the claim, you have to show that you've at least considered negotiation for an out-of-court settlement. And I think so everybody who's starting an employment tribunal claim is aware that they need to follow that procedure. So that is like this pre-action protocol. I think the problem is that when people don't have legal advice, they don't make best use of it. I mean, that's my personal opinion. And that one way of making sure they did make best use of it would be to fund legal advice for people who can't otherwise afford it, and may have difficulty negotiating the system, and may not fully understand what their rights are. So we sometimes pick up the pieces of people who've been to ACAS, it hasn't worked out, and we can then settle the case once we pick it up, even though they've been through the ACAS procedure and they haven't settled because they haven't really identified the issues, and it's just so I think legal advice alongside dispute resolution is quite important.
And District Judge Smith, I mean, I presume well you would. Do you see a lot of litigants in person, and does that bring a number of challenges when you've got litigants in person before the court?
I also see a lot of repeat business. 6 this week, one after another, just reminded me. Lots of litigants in person, usually not always one-sided, but you might not. If you can get an injunction from a judge on the basis of abuse of whatever stage, you then open up your ability to get legal aid. That gives you the ability to have a lawyer. Usually the person on the receiving end of it, I'm afraid to say usually a male, not all the time, but usually a male, doesn't have legal aid. So we've now got an imbalance before we even started, coupled with the new directive whereby if you're alleging violence, etc., one way, then you've got this in person, you're now going to find a barrister. The difficulty with that at the moment you might not be aware of is nobody's actually worked out who's going to pay, whether the barrister is allowed to see the person they're representing in court before they go into court to ask questions of the opposition. Then they walk away and the client will go, what on earth's all that about? You've come in, and now you've walked away, you can't help me anymore. That's going to be a problem. And litigants in person are regular on small claims. They just come with bags that they've not done the statements properly. And the kind of judges say, well, we'll use your particular claim as your statement because you've not done your witness statement properly. We roughly know what the case is about, get in the box. Some other judges take, I'm afraid, a little bit more hard line view. So litigants in person, they're not overwhelming us, but they are in the majority of both family and civil cases, which comes back to my point that they're not going to go to mediation or arbitration. They just don't know what to do, so they eventually issue when they've run out of patience or otherwise with the opposition. And similar with family cases, I'm afraid it's fairly bad news, but the reality of life that I live in.
Thanks. I'm Rebecca Wilkie from Advocates, we're the Bar's pro bono charity. I just think there's a real massive challenge about that education piece. What we're seeing and across the advice sector is that people coming for help have far more complex problems than they had before. It's a cluster of problems across all different sides of things, really increasing poor mental health. And the idea of on top of that trying to explain to them these avenues, I think, is a massive challenge. So I think anything around the community intermediary bit that was mentioned this morning is great, but it just feels it's more and more different issues we need people to understand in society to try and help people with a whole range of problems. So not very positive to end on, sorry, but I think, yeah, it's a massive challenge.
Yes, I think we all do.
What we would say is that really welcome there is feedback
Yeah, absolutely.
about this very important